Treason is not the reason for the season. Episode 5, Constitution and Bill of Rights. In September of 1786, before Shays Rebellion, a constitutional convention had been called in Annapolis, but only 12 delegates showed up from 5 states. Few people were interested in it and there wasn't enough people to accomplish anything. A few months later, in January of 1787, Shays and 1,500 men tried to take a federal armory in Springfield. 4 months after that, in May of 1787, another constitutional convention began. This time, 55 delegates from 12 out of the 13 states showed up. Many of the delegates were driven to the convention by fears of another Shays Rebellion being able to overpower the weak federal government. They saw a rebellion such as Shays as an existential threat that had to be stopped. George Washington was a huge advocate for the Constitutional Convention. Delegates set out to redesign the government to be much stronger so it could put down rebellions. Article 3, Section 3 of the Constitution, for example, defines treason against the United States, shall consist only in levying war against them. The Articles of Confederation had no definition of treason. But Shays' Rebellion made the founders want to rewrite the Constitution so that it made clear that men like Shays, men taking up arms against their government, were traitors. Article 2, Section 8 of the Constitution lists powers of Congress, which include the power to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively, the appointment of the officers, and the authority of training the militia according to the discipline prescribed by Congress. These 2 clauses from the Constitution make clear that militias were intended to be regulated, organized, disciplined, and governed by the government. They were not intended to be private, anonymous, terrorist groups meant to overthrow the government. These articles are especially important when dealing with what part of shall not be infringed. Do you not understand? Billy Bob Hayseed. These extremists will scream that shall not be infringed means, literally, that Congress can pass absolutely no laws with regard to firearms. But the Second Amendment is specifically attached to militia service, and the Constitution here gives Congress the powers to heavily regulate militias. How can you call forth the militia unless you register everyone for militia service? How can you organize, arm, and discipline the militia unless you significantly regulate the militia? How can you govern the militia without significant laws directing exactly what the militia can and cannot do? The idea that the Constitution gives Congress significant powers to regulate and restrict, control and coordinate the militia, but then these powers are somehow nullified by the shall not be infringed portion of the Second Amendment is absurd. Article 2, Section 2 states, the President shall be Commander-in-Chief of the Army and Navy of the United States, and of the militia. Article 2 designs the U.S. military as subservient to the government. This is an important distinction in the United States compared to many other countries where the military meddles in government affairs, and even overthrows their own government if they feel like it. In the U.S., the military is subservient to the government. The military cannot legitimately overthrow the Senate, or Congress, or the President, or the Supreme Court. The military cannot remove an elected official from office. Military personnel can't even appear at a political rally in uniform because it might appear like the military endorses one candidate over another. And that same doctrine applies to militias. The founders never intended for the military, the army, the navy, or militias, to overrule or overthrow the government. They clearly state in Article 2 the long-standing doctrine that the army and navy and militias are subservient to the government. The Constitution is ratified a year later in June of 1788. Washington was elected as our first president under this new Constitution and was inaugurated April of 1789. In June of 1789, James Madison introduces 9 amendments that will eventually become our Bill of Rights. Madison had worked on the Virginia Declaration of Rights and may have borrowed from it when writing the Second Amendment. A well-regulated militia, composed of the body of the people, trained to arms, is the proper, natural, and safe defense of a free state, that standing armies, in time of peace, should be avoided as dangerous to liberty, and that in all cases the military should be under strict subordination to, and governed by, the civil power. Virginia Declaration of Rights, June of 1776. Militias are for defense of the state, not to overthrow it. The military, militia included, are to be strictly subordinate to, and regulated by, the government. Madison may have also borrowed from the Articles of Confederation. For the defense of such state, every state shall always keep up a well-regulated and disciplined militia, sufficiently armed and accoutred. Articles of Confederation, 1777. Again, militias are for the defense of state. At this point, it should be pointed out that design and ratification of the Constitution was contentious to say the least, and the design and ratification of the Bill of Rights was equally problematic. Anti-Federalists feared the U.S. Constitution would create a monarchy and resisted ratification of the Constitution, to the point that fistfights broke out between Federalist and Anti-Federalist delegates. Anti-Federalists agreed to ratify the Constitution only if a Bill of Rights was also included. When it came time to introduce a Bill of Rights, Federalists opposed a Bill of Rights for much of the ratification period, in part because they feared the possibility that it might cause Congress to completely unravel the entire Constitution that had been so hard to achieve. Madison argued against a federal Bill of Rights, suggesting that state governments had Bill of Rights to guarantee personal liberties. But Madison saw the Bill of Rights as needed to keep the Anti-Federalists from wanting to break from the nation. He referred to the Bill of Rights as useful but not essential. Madison got much of his first draft of the Bill of Rights from the Virginia Declaration of Rights drafted by Anti-Federalist George Mason, a states' right advocate, who would want a weak federal government. Madison chose his wording with one major goal being to get the least resistance from states to ratify the Bill of Rights. When the Bill of Rights were being hammered out, there were 12 existing state constitutions that the Bill of Rights had to work with. Connecticut had no state constitution at the time and was still operating under the charter received from Charles II, King of England, from 1662. 5 state constitutions made no mention of a right to bear arms whatsoever. New Hampshire, Delaware, New Jersey, South Carolina, Maryland. 5 state constitutions tie the right to bear arms specifically and exclusively to militia service. Massachusetts, the people have a right to keep and to bear arms for the common defense. North Carolina, the people have a right to bear arms, for the defense of the state. Virginia, militia, composed of the body of the people, trained to arms, is the proper, natural, and safe defense of a free state. Georgia, every county in this state that has, or hereafter may have, 250 men, and upwards, liable to bear arms, shall be formed into a militia battalion. New York, and whereas it is of the utmost importance to the safety of every state that it should always be in a condition of defense, and it is the duty of every man who enjoys the protection of society to be prepared and willing to defend it, this convention therefore, in the name and by the authority of the good people of this state, doth ordain, determine, and declare that the militia of this state, at all times hereafter, as well in peace as in war, shall be armed and disciplined, and in readiness for service. That all such of the inhabitants of this state being of the people called Quakers as, from scruples of conscience, may be averse to the bearing of arms, be therefrom excused by the legislature. Only 2 state constitutions explicitly tied right to bear arms to both militia service and personal armed self-defense. Vermont and Pennsylvania, the people have a right to bear arms for the defense of themselves and the state. 10 state constitutions either had no right to bear arms at all, or tied the right to bear arms to militia service only. Only 2 state constitutions tied the right to bear arms to defense of self and state. These constitutions were mostly written and ratified by their states around or immediately after the Declaration of Independence of 1776, a decade before Madison submitted his first draft of the Bill of Rights for the U.S. Constitution in 1789. Madison would have been aware of all the different variations, because whatever he submitted for the U.S. Bill of Rights for a right to bear arms could create incompatibility issues with existing state constitutions and could cause states to resist ratification. The version Madison submitted most closely represents Virginia's right to bear arms clause, which ties the right to bear arms only to militia service. Madison's first draft of the right to bear arms, submitted to Congress, stated, "A well-regulated militia, composed of the body of the people, being the best security of a free state, the right of the people to keep and bear arms, shall not be infringed, but no one religiously scrupulous of bearing arms, shall be compelled to render military service in person." Madison's inclusion of a conscientious objector clause should make clear that this clause is about militias that citizens can be compelled into serving. It should also make clear that Madison had looked at all other states' right to bear arms clauses, because Virginia's Constitution right to bear arms clause makes no mention of a conscientious objector clause. Also, Madison knew about Vermont's and Pennsylvania's right to bear arms clauses that included personal self-defense. Madison knew about Vermont's right to bear arms in defense of self and state, but Madison rejected that wording in his version submitted to Congress, which reflects intent. Once Madison submitted his draft to Congress, the House and Senate debated the wording. You can rest assured that Vermont and Pennsylvania were part of the House and Senate debates. And you can rest assured that the 5 states whose constitutions tied the right to bear arms exclusively to militia service were part of the debates as well. And you can rest assured that the 5 states that had no right to bear arms whatsoever in their constitutions were also part of the debates. Everyone in the House and Senate would have been made aware of the many different state constitutions that were affected by this new clause in the Bill of Rights. 5 states had no right to bear arms at all, meaning that up until this point, they could completely ban guns, regulate guns, do whatever they wanted to restrict and constrict guns. 5 states tied right to bear arms only to militia service, meaning up until this point, they could do whatever they wanted to regulate and restrict guns outside of militia service. And guns used for militia service could be strictly regulated as well, kept at a central armory, powder kept at a central powder house, and so on. 2 states tied right to bear arms to militia service and self-defense, meaning they could put only minimal restrictions on arms. Too much restriction and it might violate the right to armed self-defense. Congress basically has 3 options to choose from for the U.S. Bill of Rights right to bear arms clause. 1. No right to bear arms at all. 2. Right to bear arms for militia service only. 3. Right to bear arms for militia service and a right to personal armed self-defense. The Federalists wanted a federal militia. Washington, who was president at this time, really wanted a militia. It may be laid down as a primary position, and the basis of our system, that every citizen who enjoys the protection of a free government, owes not only a proportion of his property, but even his personal services to the defense of it, and consequently that the citizens of America, with a few legal and official exceptions, from 18 to 50 years of age should be born on the militia rolls, provided with uniform arms, and so far accustomed to the use of them, that the total strength of the country might be called forth at a short notice on any very interesting emergency. George Washington, in letter to Hamilton, 1783. At which point, option 1, can be eliminated as a non-starter. Washington, as well as many of the founders, wanted a strong federal military to be able to put down rebellions like Shays Rebellion. When Shays Rebellion occurred, the federal government was organized under the much weaker Articles of Confederation, and the federal government could not send any military to stop Shays Rebellion. Shays Rebellion ran amok for roughly 10 months before the governor of Massachusetts organized a militia to pursue Shays and his men. Shays Rebellion is why the Constitution Convention happened in the first place. Federalists and anti-federalists agreed on one point: they wanted a federal government that could stop rebellions such as Shays. Federal access to militia was an important part of the constitutional design, and the Bill of Rights would want to secure that capability. Also, a few years after the Bill of Rights was ratified, in 1794, the Whiskey Rebellion flared up in Pennsylvania. Pennsylvania's state constitution had a right to bear arms clause for militia service and for personal armed self-defense. President Washington's response was to use the Constitution, the Second Amendment, and the Militia Act of 1792 to call a militia, march them to Pennsylvania, and crush it. Option 1 is a non-starter. The federal government was going to have a militia. If the U.S. Bill of Rights went with Option 3, a right to bear arms for militia service and a personal right to armed self-defense, then ratification of that amendment could immediately overturn any existing gun control laws in the 10 states that had no right to bear arms at all, or only a right to bear arms linked to militia service. If a state with no right to bear arms had prohibited carrying weapons in times of peace, Option 3 could overrule that law. If a state with a right to bear arms for militia service only prohibited certain kinds of weapons, Option 3 could overrule that law. If a state regulated weapons be stored unloaded and powder be stored in a safe location, Option 3 could overrule that law. Going with Option 3 could potentially cause a lot of states see their gun regulations overruled. And that would mean any of those 10 states might resist ratification of the Bill of Rights. Option 3, a right to bear arms for militia service and for personal armed self-defense, could cause some states to resist ratification. If the U.S. Bill of Rights went with Option 2, then every state is happy. The 5 states with no right to bear arms at all would have to allow militias, but they could heavily regulate the arms and ammunition used by militias, and they could keep all their existing gun regulations in place as they would apply to any non-militia situation. The 5 states with a right to bear arms exclusively for militia service would see the Bill of Rights implement exactly the same right and they would change nothing. And the 2 states with a right to bear arms for militia service and a right to armed self-defense, would also have to change nothing because a state can enumerate more rights than the federal government. For example, New York State's constitution at the time had a right for conscientious objectors to refuse military service. Citizens of New York could apply for conscientious objector status as a right protected by the state constitution. Citizens of other states might not have that right. But New York protected more rights than the federal government in this regard. The 2 states with rights to armed self-defense could protect that right at the state level. If you are a big fan of states' rights and if you are a big fan of restricting the power of the federal government, then Option 2 would be the way to go. Option 2 is compatible with all 12 state constitutions. No state would have any reason to resist Option 2, and therefore no state would likely resist ratification of the Bill of Rights based on the right to bear arms tied to militia service. So, Congress had 3 options to select for the right to bear arms in the Bill of Rights. 1. No right to bear arms at all, non-starter because founders wanted a militia. 2. For militia service only, compatible with all 12 state constitutions. Ratification supported by all. 3. Militia service and self-defense, possibly overrules existing laws in 10 states. Ratification opposed. Madison submitted his draft of the Bill of Rights to Congress. Congress had to come up with a final wording that they could pass, and then could be ratified by the states. At which point, and it seems absurd that this has to be pointed out, but apparently this has to be said. The founders weren't idiots. 35 of the 55 delegates who attended the Constitution Convention were lawyers or had legal training. One can imagine that if a member of Congress wanted the U.S. right to bear arms to match their state constitution, they would have had that discussion in debate. And everyone would have fought for the version that best matched what worked for their existing state constitution and state laws. There is a notion, pushed by gun extremists and moronic Supreme Court justices, that implies the founders were idiots. These idiots push the idea that the founders knew about the various different wordings of all the state constitutions' right to bear arms, knew of the state constitutions that had no right to bear arms, knew of the state constitutions that had a right to bear arms for self-defense, knew of the important differences in these wordings, but that the founders screwed up and picked the wrong wording. These idiots have a theory that the founders wanted a right to bear arms in defense of self and state, but they were rushed that day, the meter was running on their horse parked outside and they didn't want to get a ticket, they wanted to quit early to get lunch, they had a carriage that was in the shop and they had to go pick it up, there was an earthquake, a fire, so they cut discussions short, and accidentally approved the wrong wording. This is moronic beyond belief. For someone who calls themselves a textualist, this is the very definition of hypocritical. The inanity that is textualism is exposed in a later video. But the short version is that textualists say the proper way to interpret the law is to read the plain text of the law with the plain meaning of the words in that law, with no regard for historical context, intentions of the lawmakers, and so on. At which point, you would assume that a textualist would read the Constitution, the Bill of Rights, and the Militia Act of 1792, and interpret the Second Amendment to protect a right to bear arms for militia service only, given that nowhere in any of those documents is any personal right to armed self-defense ever enumerated, and given that the founders knew about Vermont and Pennsylvania which had wording to specifically call out the personal right to armed self-defense. But no. Textualists consistently have interpreted the Second Amendment to mean all sorts of things that aren't in the text. Because textualism is just a con. The con is explained in a later video. For now, just know that textualists who find a personal right to armed self-defense are stratospheric level hypocrites. The founders weren't morons. They wrote the Second Amendment the way they wrote it, because it said what they wanted it to say. They knew about 2 states with rights to armed self-defense, and those states were part of the negotiation process. And the founders rejected the right to armed self-defense. They also knew about 10 states with no right to bear arms or a right to bear arms for militia service only. And they knew that a federal right to armed self-defense could overturn all existing gun regulations in those 10 states, and therefore those states would resist ratification. The Second Amendment says what it means and means what it says. The right to bear arms is tied to militia service. The 2 states that have a right to bear arms for self-defense could continue that right. States that have no right to bear arms at all can still regulate guns when not being used for militia service, can mandate guns be stored in armories, powder be stored in powder houses, can outlaw public carry, can mandate guns be stored unloaded, can mandate outlaw guns not needed for militia service, and so on. Everyone is happy with a right to bear arms tied exclusively to militia service. All 13 states would find no reason to resist ratification of the Bill of Rights carving out a right to bear arms exclusively for militia service. And people like Washington, who desperately wanted a stronger military to be able to stand up to rebellions like Shays, they got a stronger military. Federalists wanted a strong federal military accessible through a right to bear arms through militia service. Federalists absolutely didn't care about a personal right to armed self-defense. Those who truly cared about a personal right to armed self-defense, like Vermont and Pennsylvania, they protected that right in their state constitutions, and didn't need it enumerated in the U.S. Bill of Rights. This idea that the founders chose the wrong wording, chose a wording that didn't align with what they really wanted, is moronic revisionism. The founders weren't idiots. Seriously. The founders weren't a bunch of screw-ups. The Second Amendment means what it says and says what it means. The right to armed self-defense was known to exist in 2 states, but that wording was rejected for the U.S. Bill of Rights. It was rejected by Madison in his first draft, it was rejected by the House of Representatives as they negotiated the wording, and it was rejected by the Senate as they negotiated the wording. And most importantly, the personal right to armed self-defense was rejected for the federal government when the nation ratified the U.S. Bill of Rights. The wording is not a mistake. It was by design. There is no personal right to armed self-defense in the U.S. Bill of Rights. However, that right is available at the state level. Here is the final version of the Second Amendment to the U.S. Constitution. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. Second Amendment, 1789. The intent of all 3 of these is that a militia is the proper way to defend the state. Militias are to be citizen soldiers, subservient the state to be trained and ready to fight, but go about their normal lives in times of peace, because the founders did not like the idea of a large standing army. And in times of war, militias are to be drafted by the government, militias are to be subordinate to their commander-in-chief the President, to defend the government and defend the state. The Bill of Rights were ratified in December of 1791. The Founding Fathers never intended for militia as terrorism, they never intended for militias to be private, anonymous, terrorist organizations designed to overthrow the government, and that is made abundantly clear in the Constitution and Bill of Rights. The Constitution defines overthrowing the government as treason, and establishes that the Army/Navy/militia are subservient to their Commander-in-Chief, the President. The Second Amendment makes clear that militias are intended to defend the state, not attack or overthrow it. Treason is not the reason for the Second Amendment. Treason is not the reason for the season.